by the end of September.
May I please?
By the end of September. Can we renew our prayer after that if
Yes, before the High Court. But you have to pursue your appeal. You have to go back before the High Court with a copy of this order and not seek any adjournment if the High Court fixes a date for hearing of the appeal.
My lords, even the imperial order does not give that impression, my lords. Could that be said
But
in the order as well?
we are giving you that liberty.
My lord, if the High Court does not give the bail, then again we may come here.
Then you go before the High Court for suspension of sentence.
May I please?
My lords, my lords. Public.
Your Lordship, just 20 dates have been passed. So far, bail application has not yet been decided, Your Lordship.
Madam, this is the problem with Allahabad High Court.
It's true, Your Lordship, but petitioner is suffering, Your Lordship. His family is there. Your Lordship, at least it should be decided. Some
Your Lordship,
may be expedited at
Your Lordship, I am
even-
appearing for the state, Your Lordship. His case is listed today as per the e-court status, Your Lordship. In court number 68, item number 108, Your Lordship, today.
108.
Yes, Your Lordship.
It's every time it is listed. I've given the list. Your Lordship may just see page 30, Your Lordship. Page 18, Your
How
Lordship.
many matters are taken up? 200.
Every time it is passed over.
No, every time it's passed over means
No,
one.
it's not taken up, but they write as PO.
Allahabad High Court judges are taking up 150 to 200 bail
200.
petitions daily. So your number is now 108. It is likely to be taken up today. Let us wait and see.
Then Your Lordship may adjourn for a
We'll-
week.
Tuesday.
Please, Your
Yes,
Lordship.
Your Lordship.
But don't begin at them.
Please, Your Lordship.
This is a case of interstate arrest. No grounds of arrest were supplied. No DD entry has been made in the local police station, and without a transit remand, I was taken away from 1300 kilometers. And the said specific plea, all these three pleas have not been traversed by the state in their counter affidavit also. Now, there is no recovery from me. My involvement is said to be in the financial transaction of 10 lakhs, and my arrest has been made after the disclosure statement of the co-accused, which has been.
Who is for the respondent? First over.
Well, they have filed the counter just to.
That is why we are asking.
Please.
Item 8, 3 judge bench.
Great.
Item 8 has.
Grateful.
Item 8 in respondent number 1, in fact, has divided it into 5 parts and thereafter sold it to further people.
Everything before 3 judge.
3 judge bench.
So the owners maybe in the meantime be impleted that.
No, sir, we can't hear it.
All these DDA matters are to be heard in terms of the orders passed by the CJI by the 3 judge bench. Any direction has to be by the CJI.
Grateful.
Your Lordship, I am requesting for a short passover. Your Lordship, this matter pertains to compensation in land acquisition proceedings. Your Lordship, the compensation granted to the petitioners is on a lower end, Your Lordship.
Madam, the deed you wanted to rely on is executed 2 years prior to the Section 4 notification.
But Your Lordship, and similarly,
There has been periodical increase. Be happy. Delay condoned. Delay condoned. Dismissed.
My lords, the petition is by owner and driver, my lords. The Honorable High Court has held that since the person was sitting on the top of the vehicle, therefore there is a breach of the
Right.
policy condition. My lords, there
Now
is
you are aggrieved because pay and recover has been ordered.
pay and recover.
Otherwise, you thought that very well.
My lords,
Victim may have
my lords, I have led evidence.
suffered injury. Insurance company will pay, so you didn't even challenge.
My lords,
Huh? No.
no, my lords, the issue is,
Really,
my
these
lords,
are all,
just one sub.
why after 549 days, tell us.
My lords, there is a delay. Once recovery proceedings initiated.
Dismissed as time barred, so that everything is kept open for the executing court.
Highly.
Dismissed as time barred.
My lords, there's an MSCT case on behalf of the family of the deceased, my lords. My limited submission is on the point that the notional income has been calculated based on 30,000 rupees, my lords. The law of the Supreme Court, I'll just pass on 2 judgments, my lords, has to be calculated even in case of deceased minor on the basis of the Minimum Wages Act, my lords. My lords may have these 2 judgments of the Supreme Court.
This is for a child.
Please, my lord.
In terms of Kishan Gopal,
No, my lord, this is on behalf of Bhavya, my
the
lord.
High Court has considered Kishan Gopal versus Lala.
My lord, now the judgment of Hitesh by Najib Bhai and Baba by Najib, my lord.
Now you can't say whether this is a Supreme Court judgment, Kishan Gopal versus Lala,
Now
the
the,
Supreme Court
please,
judgment.
my lords, please, my lords.
So now you are saying that there is a recent judgment.
Please, my lords.
Has that judgment considered this precedent?
Please, my lord, multiple high courts and the Supreme Court judgment has considered these judgments, my lord.
You are not understanding our question.
Please, my lord. My lord,
The High Court has decided
please,
on the basis of Kishan Gopal versus Lala.
please, my lord.
It's a Supreme Court judgment.
Please, my lord.
You say that now a recent judgment has been delivered by the Supreme Court,
Please, my lord.
right? Which the High Court has not considered.
Please, my lord.
So you
But-
find out and say whether the recent judgment has considered the earlier precedent.
My lord, the newer judgment does not consider the earlier precedent.
Then it is what?
My lord, but it categorically says that in case of deceased minor, minimum wages that has to be applied. Please.
Yes, Your Lordship. Your Lordship, in this case, there are 6 judgments in my favor. The only question was
Why haven't you filed an intra-court appeal before the Calcutta High Court?
Your Lordship, that was there, but there were many
If that
judgments.
was there, please go there, sir.
No, Your Lordship, may kindly see the other, because
We are granting you liberty to file an intra-court appeal. Why should we entertain directly? What is the good reason? Single judge has dismissed your writ petition, intra-court appeal is available.
Yes, Your Lordship.
Avail of that.
Yes, Your Lordship, that is.
Right? Dismiss as withdrawn with liberty to prefer an intra-court appeal against the impugned judgment and order of the single judge.
Please, sir.
Wait, please, my lords. My lords, 2 submissions here. Paragraph 19 of the impugned order, page 9 onward.
Madam, in a former round of litigation between the same parties,
Yes, ma'am.
has this issue been decided that Director of School Education does not have the power?
Yes, my lords, may kindly have P9.
If that has been decided, how can
No,
this?
no, not that the director of school does not have the power, it's the other way around. My lords, may kindly have page 124 and exit P9. So earlier
Madam, please come to para 8,
of the impugned order, my lord?
the impugned order.
Yes.
How have you attacked this finding? Tell us.
Yes, para 8. Yes, learned chief standing counsel appearing for the state and Mr. Ajayveer Pundir are not in a position to dispute that in the earlier round of litigation between the same parties, it was authoritatively laid down by the court in so and so that the validity of the election cannot be examined by the education. Now, this is factually incorrect. My lords, may kindly have.
Where have you raised this point?
Yes, my lords, may please have an exit P9, page 124.
Page 124.
Yes. So, my lords, they had relegated us to the registrar. Now, my lords,
Madam,
yes.
you can't refer to 124. You have to first refer to the
Yes.
judicial order
Yes, so,
and say that the High Court has wrongly read the judicial order.
yes.
124 is an administrative order.
No, my lords, may.
So where is the judicial order?
Yes.
Tell us.
My lords, may kindly have the order which is referred in the impugned order is,
Special Appeal 280 of 2022,
Yes.
where is the order?
my lords, that's
5th
P8,
of August 2022.
P8,
5th August.
P8,
P8
page 108 is the copy.
page 108.
Yes, my lords.
Special Appeal, yes.
Yes, my lords will see that paragraph 9 is what the order actually stated. Now, my
9.
para 9,
Just a minute, just a minute.
page number 114, internal page 7. So there were 2
No,
issues.
para 9 is not the relevant para.
No, my lords, I'm pointing out.
So,
There are 2 sets of people claiming
Yes.
to be the office bearers of the society.
Yes.
There's
So,
a Societies Act 1860.
yes,
It provides for litigation. You can raise a dispute and the restaurant will decide it. The district education officer has got no authority to
I'm,
look into
I'm
the affairs
so,
of the society.
I'm so grateful, my lord. So the precise point here is this, whether my remedy lies under 34 of the Director of School Education 2006 Act, or whether it lies under the Societies Act, which deals with the election. Now, what this particular, my most respectful submission in answer to paragraph 8.
come to para 10.
Yes, my lord.
You have shown us para 9, which is
Yes.
inconsequential. The significant paragraph is para 10. Please read
Yes.
it out.
Yes, my lords. Para 10. At the same time, we also find merit in the submissions of the learned counsel for the respondents that order dated 30th-10-2021 relied upon by the appellants was nullity, inasmuch as the chief education officer had no authority or jurisdiction to decide a dispute with regard to elections of office bearers of the management committee constituted.
This has become final?
No, my lords. My lords, may please
We have
see.
tried to understand. Two
Yes.
rival groups are fighting. It's a society.
But-
So the dispute has to be decided by the registrar.
Yes. So, my lord, may I point out?
Sorry.
Enough, enough.
We are-
If I may only.
Sorry, man.
You please go before the registrar.
So, my lords, may I please only make one request as an alternative?
Yes.
My lords may only clarify that annexure P9 will not come in my way. I'll go to the registrar of societies because P9, what they say is that because the dispute is not inter se of the society, the dispute is between the committee. It is the DO, it is only the director of education who can constitute a committee and look into it.
Very good.
That's
Nothing
with-
more. Nothing more?
Would my lords
Sorry,
only
sorry.
make?
No, man.
Sorry.
I'm-
We are not here to clarify anything. Yes,
I'm
item
grateful.
15. Notice on COD plus SLP tagged with 4228-42 of 2026.
Your Honor, this is.
Where is the employer-employee relationship? You are a contractual
To a contractor.
employee through a service provider.
Sir, but this is a special case, sir, in which for first 15 years, that person has worked.
Unfortunately, you
No,
you
sir,
are not an employee.
No, sir, but High Court has only taken the technical.
File a writ petition.
Sir, writ
Under the
petition was filed.
Industrial Dispute Side, go there.
No, sir, writ petition was filed, but it was, it is the ground.
Please take shelter of idea that it will help you.
Yes, sir. No, sir, the grounds which we have, which.
Sorry.
No, no.
Sorry.
Sir, I'll give you a small example.
Yes,
You
sir.
must have seen BVG people working in the Supreme Court.
Who are they?
Who are
Supreme
they?
Court employees.
No,
Are
sir.
they Supreme Court employees?
No,
They, can a BVG employee say that I worked here for 10 years? Therefore, I'm entitled to regularization in the Supreme Court? No.
Certainly not.
no, sir, he's asking for the regulation
Please.
because of the long duration.
be
He has worked
stretching
for over
Because
2
of the
decades.
long service. Secure an order
And the
from the
trial
court. I will
Yes.
secure an order from the court.
Yes.
Court will be very sympathetic towards my cause. 31st May will be extended till 30.
I'm-
But my lord, right now, my lord, we are my lord, come to that. My lord, the officers, my lord, Director General of Police, the Commissioner of Police, they accompany her, they are accomplices, they, my lord, abate the offense, and thereafter, my lord, I'll place on record, I have prepared it, my lord. They sit on dharna, the uniformed service officers sit on dharna with political leaders, my lord. Now, my lord, on maintainability. Lord, maintainability, there are two petitions, my lord. One by the Enforcement Directorate and another Enforcement Directorate along with one officer, my lord, who is personally agree. He is a citizen of India. And, my lord, there is a second petition by two individual officers.
28.
Yes, my lord. And I have, my lord, narrated earlier incident also where Joint Director CBI's house was ransacked, my lord. It was gherowed by people. My lord, stones were pelted. He was giving, my lord, frantic calls to survive him. To my lord,
Yes.
here, my lord, there was an evidence leading to, my lord, a conclusion that there is some incriminating material lying in one premises of a company and premises of one individual. My lord, the officers exercising powers under section 17 of PMLA goes there. They intimate the local police that we are going there. The Honorable Chief Minister, who is joined as a party, along with the Director General of Police, along with the Commissioner of Police, along with the DCP of the area, and large police force, goes there, barges into the house. Whatever material was collected was taken over unauthorizedly, which according to me, my lord, I have not hidden anything, and I am not feeling shy of saying it's an offense of theft. It's an offense of, there are several offenses, my lord, which I have mentioned. She takes it away, including, my lord, one of the mobile phones of ED officials. And, my lord, thereafter, there is no question of, my lord, my proving it. The respondent number 2 goes before the media and says that this is the great thing I have done. Lord, if this is, my lord, turning a blind eye to, Lord, this kind of things will continue, which will encourage not only the people in public life, it will encourage the officials, my lord, to not discharge their duty. They would, the central forces will be demoralized, and the state forces will feel that, yes, we can go with the chief minister, we barge into somebody's premises, we collect the evidence, we commit theft of the evidence, and thereafter, if needed, we will sit on dharna also along with the chief minister. So, my lord, I am moving an application seeking a specific prayer that let that example be set, that the officers who were admittedly present, my lord, during our exercise of powers under section 17 be placed under suspension, and, my lord, let there be, my lord, a departmental inquiry, because this is a serious misconduct, even departmental.
So you want us to suspend?
My lord, your lordships may direct the competent authority to suspend. That's the prayer. Now, my lord, we approach the High Court. Please see, my lord, what happened in the High Court, my lord, page 1.
There is no such we have not read this.
No, my lord, it is filed, e-file. Lord, I have the copy, my lord. They are served.
Served at 8 o'clock in the morning.
Yes, yes, it is served, my lord. It is served late.
I'm not disputing that.
I'm not saying. It is served late,
Yes, yes.
but it is, my lord, filed. Please see, my lord, my prayer. Lord, this is something very, very serious, your lord.
Yes.
May please take, my lord, cognizance of what is happening. Lord, first, I have quoted section 54 in my lord, context of the officers. Section 54 at page 5. Your lordships gets, my lord, page 5.
Yes.
My lord, this is PMLA Act, section 54. Certain officers and others to assist in inquiry, etc. The following officers are hereby empowered and required to assist the authorities in the enforcement of this act. One of them is officers of the police. And here police comes along with the chief minister to ensure that the evidence collected, Lord, is removed by them under their supervision, under that threat. Lord, please have a look at, my lord, the prayer. The prayer, my lord, on the same page. Pass an order or direction placing under suspension the respondent number 3, 4, and 5 and any other police officer present during the raid conducted by the Enforcement Directorate on 8th of January 26. Direct the newly implemented respondent number 7 to 9. That is, my lord, the chief secretary and, my lord, their cattle controlling authorities, my lord, which I am seeking to implement, to initiate departmental inquiry proceedings for major penalty. But, my lord, right now, my lord, we are concerned, my lord, the pattern is this. Lord, I have given the examples and I'll take your lordships to those examples, shocking examples. Lord, earlier the CBI officers go. Lord, they do not go on their own. There is a judicial order passed by this honorable court directing investigation into some cheat fund offences. Lord, there is a discharge of their duty. The police officers are the CBI officers are arrested and taken to the police station. The chief minister comes at the residence of the then police commissioner, who happens to be the director general of police today, and stages a dharna on the gates so that nobody can enter. The CBI officials, armed with the order of this court, under an obligation to investigate in a different offense, are not permitted to do that. There are, there was a bail application, and I'm placing those pleadings on record. There was a bail application of the law minister of the state being, one of the accused, a very prominent leader. The sitting law minister goes inside the courtroom and sits there with a crowd of 5,000 people shouting slogans. So there are several things, my lord, we want to show. Even in this case, my lord, this is the position. And my lord, another thing, my lord, kindly, my lord, appreciate.
Yes, 1 minute.
Yes. Lord, kindly see what happened in this particular case. Please come to page 121. Lord, we approach the Honorable High Court. Page 121 may be seen. This is what happens when mobocracy replaces democracy. 121. This is what the Honorable Judge of the High Court, Lord, records in a judicial order passed. The matter is taken up for consideration. At this juncture, a huge number of learned advocates as well as other persons enter the courtroom and create enormous disturbance and commotion. The request made by the court to maintain the decorum and dignity of the court so as that the matter can be taken up for consideration fell on deaf ears. The environment in the court is not conducive to commence or continue with the hearing. In view of such situation, my lord, the court says it's not conducive for hearing. In view of such situation, this court is constrained to adjourn the matter. Let the matter appear under the heading new motion on so and so.
Yesterday.
No, my lord, this was earlier. Now, my lord, your lordships, my lord, our innocent guess would...
Ninth, my lord, ninth.
It's
Yesterday
ninth.
the hearing took place, there was no ruckus.
Yes, yes.
Yesterday the hearing-
I'll point out what happened. I was there.
I was there, I saw what happened.
No, you
No,
should not have
I
been there.
deliberately.
Why should I have been there?
I was
Why should I have
prevented
been
from speaking. My mic.
I saw it,
Only a
it is
minute,
on
only a
video.
No.
It is on video. I saw the video later in the day.
My learned friend,
itself.
Yes, exactly.
yes, my lord, my learned friend vehemence,
Let him.
lord, I understand.
Your
Lord, yeah,
Don't put any ruckus here. Please continue.
No, my lord,
Continue, please.
our, my lord, innocent thinking can be, after reading the judicial order of the learned judge, that maybe because of the sensitivity of the matter, the lawyers may have gone, some people, other people also may have gone out of curiosity, and that might have resulted into an unintentional kind of a chaos and chaotic situation. I have placed on record the WhatsApp chats that the, my lord, the law wing of the party in power, my lord, of which the chief minister.
Intentional or unintentional, but the High Court has recorded something.
Yes, my lord. And this was not, my lord, this was not spontaneous. My lord, they were all instructed by the legal cell of the parties to go there. That is page 119, my lord. This is, my lord, the WhatsApp message, my lord, one of the WhatsApp message from the legal cell of the party, my lord. Today on 9th January, court number 5, item 10. Come everyone. Lord, he is convener, Mr. Amit Kumar Das, convener, High Court. Then, my lord, second, gathering today at 1 p.m. at B Gate.
Come everyone, as if it is Jantar Mantar.
Yes, the court is converted into Jantar Mantar. My lord, kindly read the second part. Today, 9-1 is the first. My lord, today, 9-1-26, court number 5, item number 10. Come everyone. My lord, this matter. which the learned judge records on 9-1, which your lordships have read at page 121. Next, gathering today at 1 p.m. at B gate, come everyone, will go to the procession of the Honorable CM so-and-so. Bus and vehicles are arranged. This is the preparation. Yesterday, the Trinamool Congress, the party in power, filed a petition. In that, before the petition comes for hearing, look at the position in the High Court. The Honorable Acting Chief Justice then had to pass an order that nobody will be permitted to enter in this courtroom except the lawyers appearing, and it will be live telecast. It was only because of that, my lord, precaution that some hearing took place. That also, my lord, was less than, my lord, satisfactory. My learned my lord, senior friend appeared, and my lord, we faced several difficulties. I don't wish to say that, my lord. Here, if needed, we'll file even an affidavit. His mic was being constantly muted. Lord, these are, my lord, the issues. Your lordship,
but mic is in the control of the court.
Lord, Lord, I don't wish to go into it, my lord. This is a petition for seeking protection of my fundamental rights. We are officers. My lord, the ED is not an organization only. My lord, under section 7 and 8, whatever, my lord, we recover, we don't recover for our personal purposes.
Yes. This, what is he handed over?
But it is this instructions issued by the court.
Yes, my lord. This is something very rare. Even the Honorable Chief Justice is aware that it otherwise cannot be, matter cannot be heard. This is the position, my lord. Now, please see, my lord, the act. What is ED, my lord, on the maintainability? Let me satisfy your lordships. Lord, please come to page, section 8 of the PMLA. Lord, what is the role of ED in the scheme of the PMLA Act? No, it's not just an organ, merely an organ of the union government. Lord, we exist for this purpose. That's what, my lord, I'm trying to show.
It's subsection 8 of it.
My lord, section 8, your lordships have?
Yes.
Subsection.
My lord, adjudication. Please come to subsection 8 now. Now, my lord, we do everything. We, my lord, attach the property. We take the property in our possession. Thereafter, confiscation proceedings, etc. Ultimately, what? Who is the ultimate beneficiary? Please see section 8. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering.
Subsection?
8. Subsection 8 of section 8.
Yes, yes.
I'll read again, my lord, for your lordship's convenience. My lord, we go far through.
Where a property stands.
My lord, first is attachment, thereafter, my lord, taking possession. All, my lord, there are some provisions for appeal, etc. But eventually, when it is confiscated, my lord, this is what happens. The victim gets the benefit of this laundered money. My lord, that's what I want to show. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government, please mark, to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence of money laundering. Now, my lords, what we do, my lord, just to give an example, so that I'm showing my, my lord, locus to approach your lordships. Because I represent, my lord, those victims. My lord, suppose I am investigating money laundering in a bank. The bank goes in, my lord, liquidation or something happens, my lord, to the depositors. My lord, this amount which we collect will go to those depositors. My lord, the ED has so far, my lord, collected more than 30,000 crores and which are given to the victims of the crime. So we are not just an organization. My lord, we represent the will or, my lord, the interest, if not the will, of those victims of the offense to safeguard their interest. But Lord, petitioner number 1 is the enforcement directorate. Petitioner number 2 is an individual officer. Lord, we are now, what they do is, there are 3 FIRs filed against us by 2 by the Honorable Chief Minister, 1 by the police against us, that we did something illegal, we browbeated them, etc., etc. Based on, and this is something very shocking, based on that FIR, they came to the scene of the offense which they committed and removed the CCTV footage.
So what for you went there? And what?
Under section 17 for seizure, kindly see, search and seizure.
What was under the investigation?
Yes, Manoj, please come to page B. Please come to Manoj, page B, second para.
Page?
B for Bombay.
B for Bombay, Manoj, my synopsis. Manoj, they say that we went for collecting SIR data, Manoj. A fool will not go to collect SIR data, which is available on the website. B. The petitioners are constrained to approach this honorable court under the most extraordinary, unusual and unfortunate circumstances emerging from the petitioner. As pointed out in detail hereunder, the petitioner is investigating a multi-state money laundering offence under which the proceeds of crime to the tune of rupees 2742 of 0.32 crores are derived from the illegal coal mining.
This offense, this particular scam is being investigated.
Yes, by us, my lord.
And this you went inside.
Yes, my lord. Now please oblige me by coming to page 5. Page 5. This offense is being investigated. Page 5, para 5. Para 5. Page 5, para 5 at the foot. During investigation, it was gathered that the illegally excavated and stolen coal used to be sold in Shakambari group of companies. On analysis of the documents seized from the premises of so-and-so, so-and-so and so-and-so, it is revealed that so-and-so group used to receive cash from so-and-so group against sale of illegal excavated coal. So-and-so group of companies are primarily into steel manufacturing. The group is led by so-and-so, who is the managing director of so-and-so limited and is also director in other group companies. From the evidence collected by the petitioner, it is evident that coal used to be purchased by so-and-so group of companies owned and controlled by so-and-so from coal syndicate led by so-and-so. The payment for the coal used to be made in cash. The so-and-so has not complied with the summons issued for recording his statement under section 50 PMLA. The act of purchasing illegally excavated coal from so-and-so constitutes offense of money laundering in the hands of so-and-so and so-and-so. It was therefore proposed that residents of so-and-so and corporate office of Shakambari Group be searched under section 17 as they have committed an act which constitute money laundering and are in possession of records relating to the offense of money laundering. Further investigation regarding the utilization of proceeds of crime was undertaken, which revealed that the proceeds of crime generated from coal sales were utilized by sending the proceeds of crime through both domestic and international hawala. One such hawala operator used by coal syndicate to transfer proceeds of crime has been identified from WhatsApp chats of so-and-so. Hawala firm named so-and-so was used for hawala transfers by the coal syndicate as seen from the WhatsApp chats. Intelligence was received that around 20 crores of proceeds of crime from Calcutta to Goa was transferred through so-and-so firm. The employee who handled the hawala transfer at so-and-so is so-and-so. Material evidence has been gathered which disclosed that 20 crores of proceeds of crime arising from illegal coal mining were used through interstate hawala networks layered through a chain of felicitations, converted into cash at Goa and channeled into, now please see, IPAC. This is
not felicitation, it is facilitation.
Facilitation, I'm sorry. It means, the meaning changes drastically. I stand corrected. My apologies. IPAC's operational framework. This is IPAC where we went. And for search under section 17 of the Act. Operational framework by being handed over to persons executing its work. Thus, the search proceedings were started at 10 different premises situated in Delhi and Kolkata on 8th January 26. Out of the said 10 premises, One of the premises was the
Same iPad with which earlier Mr. Prashant Kishore was associated?
Yes. Yes. 10 premises. One of the premises was the residence of Mr. Pratik Jain, situated at so-and-so, Calcutta. Sri so-and-so assistant director was authorized by Sri Bansal, deputy director, with the authorization number so-and-so to carry out the search and seizure proceedings at the said residential premises of Mr. Pratik Jain under section 17 PMLA. During the course of such proceedings at the office premises of Messrs. Indian Pack Consulting Private Limited and the residence premises of Mr. Jain, certain police personnel has arrived at their respective premises and asked the officers conducting the search to intimate a local police station if they wanted to continue their search. During the course of the search at the residential premises of Mr. Pratik Jain.
This authorization the officers were possessed of?
Yes, my lord, we showed they gone out. As a matter of fact, we intimated them in advance by mail.
The person there.
Even on that day it was shown.
To the person in charge of the premises.
Premises also, that this is the authority under which we are coming, and we are not interested in any of your political activities, if any. We are confining only to this, my lord. But I do not know what was there to hide that such a drastic step has to be taken that the Chief Minister herself personally barges into it, along with the Director General of Police and Commissioner of Police and DCP and the entire police force. Then, my lord, further, during the course of the search at a residential premises of Mr. Pratik Jain, situated at so-and-so on 8/1/2026, various digital devices were taken into possession which were suspected to be relevant to the PMLA investigation. During the course of such search at around 11:15 a.m., Sri so-and-so, Deputy Commissioner of Police South Kolkata, visited the building premises and informed the authorized officer that a complaint of house trespass has been received by the police. Thereafter, for the verification of correct facts about the proceedings, the DCP was shown the identity cards of the team and the search authorization letter. Thereafter, Sri Manoj Kumar Verma, IPS, the Commissioner of Police, Kolkata, also entered the premises as the police officers were being briefed about the search proceedings under section 17 PMLA at around 12:05 p.m. Miss So-and-so, sitting Honorable Chief Minister of the West Bengal, duly identified, entered the premises despite making categorical requests for not interfering with ongoing search proceedings under PMLA. However, violating all law and order, Ms. So-and-so, with the aids of police, forcibly took possession of all digital devices and incriminating documents from the possession of authorized officer, Sri so-and-so, Assistant Director, and left, he is the petitioner before your lordship, and left the premises at around 12:15 p.m. All the proceedings have been recorded in Panchanama, duly drawn at the premises on 8/1/26. An incident report dated so-and-so was also drawn at the said premises by the authorized officer who was conducting the search. Lord, please see the totality of this. Section 17 authorizes the search. The person searching has the authority later. The people who come, my lord, the DG, police commissioner, everyone is shown those things. That these are our identity cards. This is our authority later under the statute. And they have, my lord, this, my lord, I'll not use any adjective, my lord, but courage to take the incriminating material in their custody, which is a theft. Go and, my lord, thereafter publicly declare that this is what we have done. And this is not the first time this has happened. My lord, kindly take this, my lord, so that once and for all, my lord, this is decided. And, my lord, IPAC, whose premises is search, has not filed any complaint or even petition or any proceedings that my privacy was invaded, etc. He could not have, because it's a statutory search under section 17, but he has no complaint. But everyone, my lord, is fighting. Yesterday, my lord, there was a petition filed by the party, the Trinamool Congress. And my learned senior friend, my lord, appeared, Mr. Raju, and he said,
What are these photographs we have filed?
Yes.
Yes. Staging of dharna, etc. Surrounded by the officers, which they ought not to have been there.
Is this incident or some other incident?
This incident. These are the colored photographs, my lord. You have not placed colored photographs. I undertake to place colored photographs on record.
There is some
Kindly
color,
have colored photographs.
some color, some black and white.
No, my lord. My apologies, my lord.
No, there are color also.
Yes, my lord. These are this incident.
81, 82, 83 is colored.
In a lighter vein, Miller, some truth is colored and some is in black and white.
There is nothing in lighter way.
In a lighter
This is everything very, very serious.
I just have to smile. I need to respond. Don't go to anger.
Smiling, but unfortunately, it's
Answer all what you have said.
We listen notice, Mr. Sibal, this is very serious matter.
Yes.
We have to examine this.
I'm sorry?
Sorry, mic was off.
Yeah.
We are issuing notice
Yeah.
and we want to examine this. This is a very serious matter.
We have, your lordships will hear us, Mullahs, before doing that.
Yes, please.
Yes, Mullahs. I just want to, Mullahs, let me first clear the air. Mullahs.
Yes.
Mullahs, who is IPAC? And I'm sure they know about it.
No, I'm sorry, just because there are two.
I'm appearing for respondent number 2.
And I'm
who
for
is
1
the
and 3.
chairman? Who is the chairman of the Trinamool Congress?
I'm for 1
Right,
and 3,
the chief
state
minister.
and the police department.
Happens to be the chief minister also.
Happens to be, yes.
Yes.
But I'm appearing as
Yes.
chairman of the.
Chairman is never
If you don't please, I did not
only a
interrupt you,
minute.
sir.
Only a minute. When you say chairman,
I did not.
chairman of a party is never accompanied by the director general of police.
Allow me, sir, to argue before.
My Leonard will not decide whom we are appearing for with great respect. How will he decide that?
Mr. SG, please allow them to argue.
No, certainly.
Allow us to argue.
No, I didn't know who appears for whom. Therefore.
Yesterday this has been done by you.
Yes.
So we'll come to the issue. According to me, is maintainability. Your lordships will have to decide that the High Court cannot hear this petition for reasons that I'm sure your lordships will give. And if the High Court can hear this petition, then why should your lordships hear it?
No, we are very much disturbed with the way High Court has been almost
No, the hearing took place yesterday, Mullahs.
yesterday, but
Yes.
what happened?
But that's not going to be repeated. That's not going to be repeated, Mullahs. The question doesn't arise. If it took place yesterday, it will take place tomorrow also. So your lordships will have to now assume that the High Court can't deliver justice. Fine, I'm not saying don't. But Mullahs, your lordships will have to say that, Mullahs.
You cannot put words into our mouth.
No, I'll say your lordships.
Assume and what we will not assume.
If your
is our
lordships,
business.
of course.
Mr. Sibal.
Of course, but I'm not saying, Mullahs, your lordships.
Please argue your case.
I'm going to argue, Mullahs.
What we will do.
My argument at the initial stage is
please proceed
that
with your
this matter should be heard by the High Court. Because the High Court is the court which has the 226 jurisdiction. It will hear the matter, render findings on the basis of whatever they are arguing there, Mullahs. We have a right to appeal, and then we can come to this court. That's the hierarchy of courts, Mullahs. And they are now filing parallel proceedings, not wanting to go to the High Court. And their argument is on the last day, that on the 9th of January, there was a ruckus, and therefore proceedings could not take place, which is correct. And then on 13th of January, the Chief Justice passed this order. And then yesterday, a hearing took place, and the hearing was peaceful, Mullahs. There is nothing to assume that the hearing cannot take place, Mullahs. That's point number one.
Yesterday, Mr. Mehta's client sought time, saying that we have filed in Supreme Court.
Yes.
High Court, can I finish, please, sir? So the High Court said, we are adjourning it sine die with liberty to come back the moment you think the Supreme Court is over, etc. So yesterday, without any ruckus or any involvement, they sought adjournment specifically in the statement, which is why the yesterday order was passed. That's only a fact which should be noted by your lordship. And they said that the matter is coming today.
Correct. Now, Mullahs, on the contentions on facts that he has made.
Yes.
Mullahs, IPAC, we all know, Mullahs, is an entity which takes care of the elections in West Bengal. A formal contract has been entered into by the party with IPAC way back in 2021. And I assume, Mullahs, that the ED knows about it.
No, elections in West Bengal are conducted by IPAC or by the election?
No,
Commission?
all the material, there's a confidential material for the purposes of this agreement. Confidential information shall mean any and all information, including but not limited to sensitive or non-public information of any nature whatsoever. There's a whole series of data, of documents, of information, of facts. All that is confidential and it is kept there. And I'm sure that the ED knows about it. He knows about it. So when they went there, they knew that there's going to be a lot of information in respect of the party, the candidates, what is happening, what is the program, where we're going to go, what we're going to do. I'm sure they knew about it. So, Madam, the first question that arises is, why was the need to go there in the midst of an election? Why was the need to go there in the midst of an election? Now, Madam, in the coal scam that we are talking about, Madam, the last statement in the coal scam was recorded on the 24th of February. 24th of February, 2024. What were they doing in 2024? What were they doing in 2025? And why were they so keen in the midst of an election in 2026? And we're saying we want for what? SIR for what? It is all the information that's in the computer. Once you get possession of that information, how are we going to fight the election? So, Maharaj, which is why the chairman, Maharaj, the chairman has a right to go. It's the property of the party. So the chairman then went, because they went to the house of IPAC, the individual Pratik Jain, in the morning, in the morning, at 6:20 in the morning.
Yes.
ED went at 6:20. Chief Minister only came at 12 o'clock, Maharaj. And went away at about 12:15.
They collected everything and went.
Maharaj, this is, you can make any statement you want to make, Maharaj. There is a provision in the BNSS which says that kindly 105. And the lies will be demonstrated if they show the video. Take 105 of BNSS. We are also very disturbed, Maharaj. Extremely disturbed as to what is happening. Why should ED Maharaj wait for 2 years to come to West Bengal and go to an office which is a party office, which has all the data with all the information? It's part of party office. Kindly see 105. The process of conducting search of a place or taking possession of any property, article or thing under this chapter, or under 185, including preparation of the list of all things seized in the course of such search and seizure, and signing of such list by witnesses, shall be recorded through an audio-video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate. Please show that recording. Everything that is in the statement will be proved to be a lie. That respondent number 2 took all the devices. It's an absolute lie. And it's contradicted by their own Panchnama in this petition. I read the Panchman out to you. This is very unfortunate, Maharaj. And that's why, in a matter of this nature, Maharaj, and I'll come to the law a little later, Maharaj. This is just to create prejudice. Now kindly come to the Panchnama. 66, Maharaj. I'm going to show you. Page 66. Maharaj, kindly come to 66. We above named Panchas. Your Lordship sees that? And kindly come. They show that, search was conducted. Now kindly come to 68. Yes. Kindly see. During the course of the search, so-and-so inquired about the ongoing proceedings. At 12:05, search started in the morning. No seizure took place. Till 12:05, no seizure took place. And inquired about the ongoing proceedings, informed her about the proceedings. At around 12:15, took possession of material being seized via laptop belonging to Pratik Jain. Now, laptop belonging to Pratik Jain will have all the information about the election. Every piece of information. Several documents and iPhone Pro belonging to Shri Pratik Jain have left the premises. Several documents. Where are all the devices? He just read in the petition that she took away all the devices.